Welcome to another episode of Pinsky Law Presents, and today we're going to talk about privacy and surveillance of your volunteers and employees. Now, today's lecture, more information can be found in the Fire Department Law and Management Resource Manual, pages 517 to 525. You can order it from www.pinskylaw.com. So we're going to talk today about workday surveillance, and just to be clear, we're talking about surveillance of volunteers and employees in and out of the station, in and out of your vehicles. We're going to talk about all these topics. This is a huge topic, much bigger topic than normal because there's so many federal and state laws that apply. But we're just going to focus on one sliver of this massively important topic. So today we're going to talk about three types of monitoring: audio recording, video recording, email monitoring, and a little bit about your lockers and other personal areas around the firehouse and ambulance service. The Electronic Communications and Privacy Act, it's a federal statute that governs employer surveillance. The ECPA generally prohibits interceptions, disclosures, and intentional use of wire, electronic, or oral communications. In other words, two people communicating back and forth. Federal law prohibits intercepting or attempting to intercept these wire, oral, electronic communications. Federal law prohibits disclosing the contents of any wire, oral, electronic communication, whether it was known that the contents were impermissibly accepted or should have been known. And federal law finally also prohibits intentionally using or attempting to use the contents of any wire, oral, or electronic communication which was impermissibly obtained. In other words, federal law prohibits trying to get it, disclosing it, or using it. Now, there are two exceptions to this federal law. If you intend to monitor telephone or audio communications, you could obtain consent to monitor these communications. You have to get the employees' or volunteers' consent in writing. Do not go on implied consent, meaning, well, I thought you knew because I mentioned it at a meeting, or it was in minutes somewhere, or I had a policy buried in a book somewhere you've never seen. And just note, this isn't just federal law. It is a Class E felony in New York State to eavesdrop on a conversation between two people without the consent of at least one person. In other words, you can record in New York State your own conversation to which you are one of the two people on, but you cannot record the conversation of two other people. That would be a felony. Now, there's another exception to the federal law, which is if it's performed in the ordinary course of business, where the purpose was justified. It was a routine business practice to do so, and notice was provided to the employee. In other words, no surprises. We're going to talk more about this in a couple of minutes. Now, what about video surveillance? Well, video surveillance of employees and volunteers is very limited. Silent taping is different than turning the audio on. So the video is not really a prohibition under federal law. Audio recording actually is. And think about why. There's video cameras everywhere, at the grocery store, on the streets. That would be a big burden to prohibit that. But audio taping, that's a very different issue. If you activate audio on the camera, federal law is going to apply. Now, New York State labor law, section 203-C, states, no employer may cause a video recording to be made of an employee in a restroom, locker room, or room designated by an employer for employees to change their clothes unless authorized by a court order. So let's be clear. Please do not put video cameras, even without audio, in any place where people are taking off their clothes. These are traditionally considered private spaces and the health or personal comfort areas for people. Nursing rooms, first aid rooms, any place anyone's going to take off any part of their clothes should not be recorded. Now, federal law also comes into play with the National Labor Relations Act, and this is a very small sliver of a much bigger topic. But when employees are engaging in protected activities, such as they're talking about self-organizing, they're writing things on a board about forming a union, or they're talking and having meetings about bargaining collectively, you cannot spy on them at all by putting a video camera in a place where they're known to be meeting. Again, much bigger topic, but what the law basically wants you not to do is to record in any place that would prohibit or cause employees to say, whoa, we can't meet on premises because they're going to be watching us, and now we got to go to some restaurant and do, try to come up with plans there. You have to have a place for employees to come together to discuss workplace issues, and you can't record them while they're doing this. Now, New York State General Business Law, Section 395-B. This is going to apply to pretty much all of you. It prohibits an owner of a building from installing or maintaining or knowingly permitting the installation of a two-way mirror, a camera, or another viewing device, or from installing a video recording device for the purpose of surreptitiously observing the interior of any restroom, fitting room, washroom, shower, or hotel room. Now, the second part you're just a little bit sick for doing, and we should all know, let's not be putting any camera into, again, a place where people might be taking off their clothes. But you cannot install a camera or other viewing device in these places, and it's actually jail time of 15 days or a fine of up to $300. But here's the issue. A lot of times you may have installed a camera in a hallway, and the bathroom door, if seen to be opening on the camera, that you can see in, or a changing room door where you can see in, that would violate this law. You cannot allow the camera to view into these private areas at any time, even if it's just temporary where the door opens. This is where fire departments, ambulance services, and other employers will get into trouble. Now, building recording devices. In every area, every single area where a camera or other recording device is used, you must ensure that there is at least a sign with 3-inch or greater letters that state recording in progress. And if audio is recorded, it must state audio/video recording in progress. This should be in every single hallway and room entrance where recording occurs. So if I'm walking into a room where I could be on camera, there must be a sign in that room. One room, one sign. One building, many signs, right? One sign on one building is not enough. You have to state in every area where you are going to be recorded that you could be on video or audio. Well, what about dash cams? Dash cams, which are in vehicles, certainly have the ability to record audio and video. Same rule. Provide a 3-inch label in the driver and the passenger area which states audio or audio and video recording in progress. Make sure that you tell every passenger in that vehicle that what they say or what they're doing could be on video. So what's the solution to the video policy? Well, multiple steps, mostly what we've just talked about. You create a written policy regarding security cameras, video monitoring, audio monitoring, if you're going to do it. You identify the purpose of the monitoring, including security of the building, safety of the firefighters and EMTs, preventing improper computer usage, prevention of theft, etc. You identify the areas, the entry doors, the hallways, certain common areas, workstations, supply rooms, narcotic supplies for an ambulance service. You give notice to all employees, including your volunteers, that the security cameras are going to record in these areas, both in the policy and by the signs. And you don't have to actually ever monitor the camera feed. You just have to tell them that you could monitor the camera feed. And I would definitely require everyone to acknowledge that they've received this policy. Otherwise, they're going to claim, I never saw it. Now, what about email monitoring? You know, the federal law we talked about before, the ECPA, it does apply to emails. But same precautions. Give notice that the employee or volunteer understands that the computers and networks belong to the employer, the fire department, the ambulance service. Give notice that you will monitor or may monitor the emails that are sent or received using the department's computers and networks. Whether you do or don't doesn't matter. Reserve your right to monitor these emails and communications, even if you don't intend on doing it. A third-party administrator may have access to the network, but tell the users that a third-party administrator may have access. And let them know that there's no privacy in the emails that are sent using the department's network, using the department's computers or servers, and certainly if the department gave you, the employee, if the department gave them an email to use, make sure they know that all the content is not protected and that it should be used only for government or fire department or ambulance service business. And once again, require the employee or the volunteer to sign an acknowledgement of the policy and consent to the monitoring of emails. And I'm less concerned that they consent. I am much more concerned that they acknowledge that you told them what you could do for monitoring. What about passwords? You know, you give someone a password and what's their assumption? You can't see it. You can't get into my email. You will never look at it. But that frankly isn't true. You need to tell everyone that just because they're given a password or a passcode to the computer or to the email, that there is no expectation of privacy. That, again, the computers and networks belong to the employer, that there might be a third-party administrator who has access, or the employer might look at their emails or computer network or their usage or what sites they logged on to, and that the passwords and passcodes are only to protect the computer communication from outside, not to protect the volunteers or employees' rights. This is not to protect the employee from observation by the company. But if you don't tell the volunteers and employees about this limitation, they will have the right to tell you you are not allowed to see my email communications or to look at my computer usage. What about text messaging? All the same thing. If you give a phone to your employees or your volunteers, like your fire chiefs or your director of operations, they're going to assume, without you telling them otherwise, that their text messaging communications are private. Same rule under federal law. The ECPA probably applies to emails and texts. You want to give notice that they understand that the pagers, text messages, whatever, belong to the employer, belong to the fire department or ambulance service, that you're going to monitor them, right? And again, require acknowledgement of the policy. Now, closing out, we have one huge issue we should talk about. What about personal spaces? Well, again, notice, notice, and notice. You should give notice that even though we give you a locker, they can be searched and you have no expectation of privacy. Even if you put a lock on a locker, just like a password on an email, you have no expectation of privacy from the employer that we at any time can look at these areas. Give notice that emails can be read. Internal mailboxes are not private storage bins. A lot of places use their department email, their department mailbox as a private storage box. Tell them it's not. Desks, drawers, file cabinets, let them know these are not private storage boxes. They belong to the fire department and we can search them at any time. Mail that's not marked as confidential may be opened. If you as fire chief receive something and it doesn't say confidential, state that the organization can look at the mail. Texts, phones, phone logs, phone records, call logs, call receipt logs, all belong to the fire department or ambulance service. Social media posts about the employer's organization, posting anything on the website of the organization, not confidential. Voicemail, not confidential. But again, the employees, the volunteers will have the right to assume that these are confidential if you don't have a policy. If you need help drafting a policy, again, this book, it will give you all the answers. And finally, the expectation of privacy. You have to let them know. Internet security logs can be reviewed. You know, if you don't know, when you type anything on a computer, it is possible that the organization has put in a typing recording program. Of course, they need to tell you that they're doing that, unless they've gotten a search warrant. They're trying to discover something that you're looking at sites you shouldn't. But generally speaking, you as an organization need to tell your volunteers and employees that you can look at security logs, that you can look at internet file transfers, uploads and downloads, software that's uploaded or accessed, or internet sites that are accessed. You're going to look at the downloads, right? So we want to make sure that we give full and fair notice. And look, I could have summarized up almost this entire presentation in just a few words: notice, notice, and notice. Provide notice, limit their expectations of privacy, and let them know what you could be looking at and monitoring. That's it.